penetration, but from reading this.
He didn't say that. I said it because
Okay.
I was just talking about the legal issues with that. So,
But I mean, having a child having her brother lick his butt.
that was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
That's a different one. Yes.
What is wrong with you?
Well, Your Honor, I'm not trying to beat around the bush.
CR 0543, State of Texas versus Wilberth, Vill. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jason Goss for Mr. Villamel.
And are you Mr. Vill?
Yes.
Are you going to have to speak up so I can hear?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Vill, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on count 3 and waiving counts 1 and 2.
Any objections?
Yes.
Did you understand you're charged with the offense of aggravated sexual assault of a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years in prison and life and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
No.
Counsel, has your client had a chance to confer with an immigration attorney?
I have conferred with an immigration attorney. I have informed him that a plea to this is, he's actually a permanent resident. A plea to this would be a certain denial of future permanent residency and deportation after serving a prison sentence, which is what he's pleading to.
All right. Mr. Vill, did your counsel advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
Before we dive in, just a quick note. This commentary is created for educational purposes designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What you're watching here is a courtroom moment that quickly spirals into confusion, frustration, and serious legal consequences. On one side, we have a tenant who believes promises were broken and agreements were manipulated. On the other, a property management team claiming the legal process was followed correctly. But here's where it gets interesting. The judge is already struggling to understand the argument being presented, and in court, clarity is everything. If the court can't clearly follow your claim, your chances of winning drop dramatically. So the big question for you watching right now is this. Do you think Ms. Malik has a legitimate legal complaint here, or is this simply a misunderstanding of how court rulings actually work?
What was that again? Sorry.
I said, did your attorney advise you of the consequences of entering a plea in this cause number, either no contest or
Yes.
guilty, and how that applies to federal immigration law?
Yes, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from the United States, or the denial of naturalization?
Yes, Your Honor.
Do you understand the consequences of that the defendant has knowingly and voluntarily waived his right to jury trial? Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Sure.
According to the plea, you're pleading on count 3. Punishment is to be assessed at 15 years in the prison. There are no applications. There's to be no contact with the complainants, and there's Chapter 62 compliance. Did you understand?
Yes, Your Honor.
All right. Here's my question, because I see that affirmative finding of family violence has been crossed through. Is this
Exactly.
complainant his relative or not?
Yes.
Okay.
Yes.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, sir.
State, is that the plea?
Yes.
Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written state any evidence to support the defendant's plea,
I know we offer State's Exhibit number 1 and all attachments.
Okay.
showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty.
What he has pled to is a single count of a single time of sexual assault of a child, which is aggravated sexual assault of a child. He has agreed to do this early on in his process. He is not contesting his guilt, and he is not contesting what's going on. He's agreed to go to prison, and 15 years is a substantial amount of time.
State, why should I accept this agreement?
Your Honor, the child is very young. She's in therapy right now. I discussed it with the mother. And this is, there is a desire to get closure early on in this case, Your Honor.
So
At this point, we haven't had to
penetration, but from reading this,
He didn't say that. I said it because
Okay.
I was just talking about the legal issues
Yeah.
with that. So
but I mean, having a child having her brother lick his butt.
that was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
That's a different one. Yes.
What is wrong with you?
Well, Your Honor, I'm not trying to like beat around the bush. She was showing me her crotch, and that's.
And you got turned on.
No, I didn't. I'm telling you, I'm not like physically like. Well, I did get turned on, but not. Well, after a while, she just kept doing that. Tell her not. You know what I mean? Like,
You blaming a 6-year-old?
I'm not blaming my
Your
6-year-old.
Honor, my client was sexually abused when he was a child. Offender, almost certainly be deported. He'll never live. He's been in this country since he was 2 years old. He will never live in this country again legally, and he will.
So
have to
he's
live
being released after he does his time, released to go somewhere else and deal with his trauma that may result in him molesting some other child?
Well, he has what he is hoping to do is, as you know, the TDCJ system offers a pretty comprehensive sex offender counseling and treatment. And of course, you know, he will at some point be wanting to go on parole. He knows that he's going to have to complete that to do that. We have talked about it, explained it. He's going to take the opportunity to do that, as well as other programs that are offered in TDCJ. He is motivated to do that. And you know, at some point when he is released, as I said, he's going to go to a country that he has basically never lived in his entire life.
What country would that be?
Mexico.
They have nice beaches there.
I try not to hurt her.
Wait, are you saying that you were molesting her, and as you were molesting her in such a way because you didn't want her to hurt her?
No, I asked her, you can put this in your mouth. That's it. And she said no. I said, that's fine. Okay, that's it.
No, this is a penetration.
Your Honor, if what he has pled to is, and what he confessed to is by penetrating the anus with his finger.
Mm-hmm.
And he had told the police when they asked him that he told the police that he did that at the time, which is another thing. He was honest with the police. He told them what he did.
Here's a critical legal moment that many viewers might miss. Ms. Malik is arguing that an attorney shouldn't have been present in the earlier small claims case, but that's not always accurate. In many jurisdictions, attorneys are allowed in small claims court, sometimes with limitations, but their presence alone doesn't invalidate a judgment. What really matters is procedure. Did she attend the hearings? Did she respond to the notices? Courts rely heavily on attendance and documentation. If someone misses court dates, the judge can issue what's called a default judgment, which means the other side wins automatically. So now, the real legal battle isn't about the original dispute. It's about whether there's a valid reason to overturn that default. And that's a very high bar to clear.
How he has confessed to you and now that he has done it. And what
No, he pled no contest.
He pled no contest because I advised it because there's a civil case going on, but that's a legal advice that he was getting from his lawyer.
I understand, but he pled no contest. So again, we're back to what were you thinking? Because I'm trying to figure out where you're coming from to figure out whether I should follow this plea or not.
Sorry, Your Honor, I didn't do it. I didn't do it to like hurt my daughter. I tried. I'm begging and telling you, please. I'm telling you, please. I'm not trying to.
The way you're explaining it to me, you're making it seem like it was an accident.
No, it wasn't
So was it an accident or not? Because you're telling me you just grabbed her and you're making it seem like your finger just accidentally penetrated the
The
anus.
thing is, I just don't know what she wants. Like, she's spreading her legs at me. Like, what do you want me to do? And like, she's spreading her whole vagina at me, like at least 4 or 5 times. Dropping her pants, like literally. Like, it's not like I'm telling you like my actions were right.
I know. I'm just trying to figure out where you are mentally. And yes.
So if I grab my daughter's butt and I throw her on the bed and I didn't like forcefully sleep.
Your Honor, at the time he told police officers that he had put his finger inside of her anus.
So it wasn't accidental. Am I right in assuming that?
He did not tell the police officers it was accidental. I don't think that he's trying to communicate that to the court. All of those things that we have for people who are charged and people who are convicted of this, all of those things we're doing here. He's going to the penitentiary. He's going to be a registered sex offender for the rest of his life. All of those things are what's happening in this situation for people who have this apparent or this abhorrent behavior. He's obviously injured this child, and he understands that. He's signing for 15 years to go to prison because of what he's done.
All right. So this is a life case, honestly. So State, you want to explain to me why the court should follow this 15 years?
Your Honor, this was done, having been in this position, I have seen these cases that languish for 4, 5, 6 years. And I had a discussion with the mother, and the benefit of the child was to get this done, have no right to appeal, so the child could move on.
If you all want to reconfer on that, you can.
Okay.
All right.
Your Honor, 2 things. I'm set in jury trial in County Court 13. They're starting to pick the jury now.
Oh, tell them you're in felony court. I'll call County Court 13.
It's Judge Skinner. It's County Court 13 impact.
I'll call them. So if you all want to confer and see if he's willing to accept 20 years.
I can't talk to my client about something like this in the matter of a few minutes. I mean, this is something that we just asked for a reset. If that's what the court is asking us to do, it puts too much pressure on the attorney-client relationship for me to talk to him in the box about a complete reworking of this plea bargain. I spent hours with him in the jail, going over discovery, doing all this stuff, and this is. I'm asking for a new setting.
All right, Ms. Ferguson, recall this for tomorrow.
On this case, Judge, the last we were here, the court declined to follow the plea, offered the client 20 years. We are respectfully, we have given the court reporter payment for the record, and we are going to respectfully file a motion to disqualify the court in this proceeding.
Okay.
So
is your client not accepting the 20 years?
My client is not accepting the 20 years as it's been offered by the court.
All right. Ms. Ferguson, can you put this on the jury trial docket, please?
Your Honor, I've been informed that it will take 4 days for the record, including this one. And so,
Well, whatever date, the first date of jury trial, that's the date of jury trial.
understood.
Okay.
Thank you.
first jury trial available for this case.
We wanted to respectfully inform the court that if our intent is to file a motion to disqualify the court from this proceeding, and that at this time, the court's offer of 20 years to the client is rejecting because we are waiting for that motion. We have tendered a check to the court reporter in order to get the record. And then once that record is received,
And this is where the case ultimately lands. From the judge's perspective, the issue before the court was extremely narrow: whether there was a legal reason to overturn the existing eviction judgment. The judge repeatedly emphasized that the eviction followed proper procedure. Missed hearings led to a default judgment, the landlord requested an eviction order, and the court signed it. Whether there were misunderstandings about agreements or conversations outside the courtroom simply wasn't enough evidence to legally reverse the ruling. In the end, the judge denies the motion, gives a short grace period, and the eviction stands. Cases like this highlight an important lesson about the legal system. Procedural rules matter just as much as the underlying dispute. Missing hearings, filing late motions, or presenting arguments that aren't directly tied to the legal issue can completely change the outcome of a case. Now, we want to hear from you. Do you think the judge handled this situation fairly, or do you believe Ms. Malek's concerns deserved another chance in court? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
the motion and we can go along that process.
All right. Well, your plea deadline date has expired, so the court will not accept any plea bargain agreements in this case. Your jury trial is set for August 8th.